All right, all right. Good morning, everybody. I know most of y'all are gonna be at work, so I won't make this live too long. Oh, I haven't had anything to eat yet. I'm getting hungry. I'm drinking some water right now. Well, it's actually not water. It's like herbal tea, something like that, but it's made out of herbs, so there's no sugar or anything in it like that. It's just straight herbs. Okay. So I wanted to talk about something because I got this. A woman sent me a message last night, or well, this morning around sometime. I'm not really sure what time. So let me show you. Let me go to my screen share. Let's go down here. Go to the community section, and her question was, it's on this it's on this flyer right here, this post right here. So let's go down right here. Um, this woman, well, I think it's a woman. I could be wrong. If I'm wrong, I apologize. But anyway, this is what it says. Will you ever do anything pro bono? Well, she spelled it wrong, but I get what she or he is saying. I get it. And the answer to my question is, I already have. There are some stuff there. There are some pro bono things that I do privately. That I kind of don't even talk about it actually. But it's not going to be drafting a whole motion for somebody or a brief for somebody or litigating their entire case. I'm not gonna do that. Um, that stuff takes time. Generally speaking, it takes me. I can't speak for nobody else, but it takes me in order for me to get things the way that I want it done, depending on what it is, anywhere from 1 to 3 weeks. 1 to 3 weeks, sometimes a little longer. And this stuff takes time. I might be in here all day reading cases. That stuff, it's extremely exhausting. All right, but let me get back to what I was saying about I already have. So what do I mean by that I already have? Well, I have 159 videos on here. That is me doing pro bono work. I don't charge for everything that I do, but I do believe that my time is valuable to me, and especially my experience also, both of them. Um, and I do believe that I am worth what I'm asking for. To be honest with you, I think I'm worth more, but I know people can't really afford this stuff. This stuff is expensive. If you go to a law firm trying to hire somebody to do this stuff for you, you're looking at 4 figures off the top just for them to even start the case. Um, that's just generally how it works, and it's just getting more expensive. I remember at my settlements conference, the federal magistrate, so-called judge, he was telling me that attorneys have went up, to settling cases now. They've went up to like 50% just for them to take your case. That is ridiculous. 50%. I think it used to be maybe 25 or 35%. But he told me it went up to. He said the highest he's seen was 50%. And I said that's ridiculous. That's excessive if you ask me. That's extremely excessive. But what you gonna do? You don't have any other. You're not gonna get that so-called money unless you hire them, unless you know how to do this stuff yourself. And then I really think that there's a gatekeeper, that they're doing some gatekeeping over that stuff, man, because they just hate. hate pro se litigants, at least the ones that know what they're doing. They're not going to ever make fun of anything that I file in court. They ain't going to do that to me because I know what I'm doing, and I'm not going to make arguments that are controversy uh, that typically go against the status quo and will make these people violate your due process rights. And what I mean by that is they're not going to give you a meaningful and proper disposition of your case. They're not going to consider it right. You think they're not going to do that? You can forget about that. They're just not going to do it. All right, so let me get back to what I was saying. I'm sorry about that. I got a little sidetracked. So I posted this a while back. Do you need help drafting motions? All right, 22 people said yes. I don't see, these must be new people on here. I'm not really sure if they're new or not. They must be new subscribers, but I don't see how, unless they are new, that you need help with drafting motions. Because let me go and show you. Let's go back to the videos. Let's go down. Let's go down, trying to find a video. Where is it at? All right, right here. This is not the only video that I did. Look at this. How to type a motion to dismiss. How to type a motion to suppress. Let's see, what else? How to draft a motion. This video is a year old. If you don't know how to type a motion, you need to go and watch this video right here. This is me doing pro bono work, telling you how to draft a motion. Now, I do understand that there are going to be, you may have some questions that didn't get answered in this video. That is because I don't know what your questions are going to be. I kind of have an idea, but I'm not sure. And so since I'm not sure what your questions are going to be, that is why I have made myself available for you. All right. That's why I made myself available. So if you want to learn how to properly draft a motion like a professional, because my paperwork is flawless. All right. My paperwork is flawless, and I make pretty good arguments in my paperwork. If you want to learn how to draft a motion, then I strongly, and if you want if you want some one-on-one time with me, then you need to register for this course. That is why I intentionally limited it to 10 students. I don't take any offense to what me calling you a student, because I'm not a guru, okay? But I do know what I'm doing. All right, but I will always and forever be a student of law. Let me go back. Then you need to register for this course. All right. You need to register for this course. I don't know what else to tell you. If you cannot afford $200, I don't know what to tell you, because you can do installment payments and do that. If you can't afford 8 $25 payments plus the transaction fees, I don't know what else to tell you. If this is what you want to do, if you want to learn how to litigate your case, this is what you need to do. You need to register for this course. That's what you need to do. If you can draft a motion to dismiss, you can draft, not a motion to dismiss. If you can draft a motion, then you can learn how to draft anything, because all of the stuff is the same. Generally speaking, it's all the same thing, y'all. That is why, again, I have made myself available for 6 days, 18 hours, 10 students. So when you come in, you're going to get 3 hours. We're going to do 3 hours on this day, 3 hours on this day, and 3 hours on this day. And then the next week, we're going to do it 3 hours again, 3 hours again, and 3 hours again. I think that's enough time. All right. So you need to have all of your questions ready. Now, just to let y'all know, I feel like I have to say this because he who seeks equity must do equity, and he who comes into equity must come in equity with clean hands. This is only half of the work. You're gonna have to do the other half because you're gonna have to know what your rights are, and the only way that you will know what your rights are is you're gonna have to do exactly what I tell you to do, which is exactly what I did. You're gonna have to read cases, and I mean you're going to have to read a lot of cases because that is how you're going to know what your rights are. I know what my rights are. That's why when I sued the police, I knew I had a good idea that I was gonna win. Um and I did win because I settled the case. We didn't go to the jury or nothing like that because the district judge she did something that just made me not trust her at all. I didn't feel like that I would get um how do I put this? I'm gonna say this. I reasonably questioned her impartiality to remain neutral and independent and unbiased in my case, if that makes sense. It makes sense to me. And so as soon as she did that, I was like, oh no, this ain't gonna work. Let me go and settle this case. And I settled the case. But back to what I was saying, you're gonna have to read cases. I cannot read these cases for you um all the time. You're not gonna have me here all the time. But if you come into this class and we can go over some, we can do all that stuff in this class. We can do all of that stuff. Have all your questions ready. Write down the stuff. I don't know what else to tell y'all, man. I don't know what else to tell y'all. All right, but let me elaborate on this stuff a little bit more on why you should not want me to do all of your work for you or any of your work for you, in my opinion. Um, because if I did, in my opinion, I think that will make me a bad teacher and you a bad student. And what I mean by that is, let's say that we file a motion to vacate the judgment because it's void because the judgment was issued in a manner that is inconsistent with due process. So they violated due process when they entered the judgment, and as a matter of law, they lose jurisdiction over you. Okay, let's say we do that, and I draft it up. Number one, that tells me that reasonably allows me to conclude, even though I may be wrong, because reasonable conclusions can be wrong. But that reasonably allows me to conclude that you don't know how to do the paperwork. And since you don't know how to do the paperwork, that reasonably allows me to conclude also that you don't know how to argue the case. You don't know what you're doing. But you file it anyway, and you get a hearing schedule. All right, so now you have a hearing schedule. They're not going to let me come in there and argue that case for you, and I'm not going to travel all the way to where you are for free to argue this case for you, even if they would let me argue the case. I'm not going to do that. You should not expect something of value in exchange for nothing, unless that's what I want to do. Put it like that. And sometimes I do charity. No disrespect. I'm not calling y'all poor or nothing like that, but sometimes I do that. But I'm not doing that. So long story short, so you get to court, right? So it's just you. You didn't draft the paperwork. You didn't do the research. You don't know how to argue the case. But when you get in there, they're going to start asking you, why do you believe the judgment should be vacated? What are you going to say? What are you going to say? Because that's what they're going to do. I'm not 100% sure, but if that's what they're going to do, but that's what they did to me. I'm telling you based on personal experience. That's what happened to me. And when I was asked these questions, I answered. The so-called judge in this administrative agency masquerading as a court asked me, why do I believe that he no longer has in personam jurisdiction over me? And I said, well, Your Honor, the judgment was issued in a manner that is inconsistent with due process because I don't know who is doing it, but somebody is filing motions in here, and they're not serving me these motions. I'm not getting these motions. I haven't been served any motion so far, but I'm seeing some orders that are subsequent, and they're being issued as a result of somebody filing these motions in here. And also, there are some orders relating to some of these motions that I haven't gotten, that I have also not received either. So essentially, there's a due process issue going on here. You have to get a copy of everything that they file in that docket. Everything. I don't care if they had jurisdiction over you when the case first started. That don't mean they get to keep it and at the same time violate due process. No, they don't. That's not how it works. He who seeks equity must do equity, and he who comes into equity must do so with clean hands. Y'all gonna have to study this stuff for yourself. I can show you how to. I mean, even though I've already have, because I have videos on here, me doing pro bono work, showing you how I do my legal research. Let's go to the videos and let me show you. Let's see. Well, let me comment on this. A lot of y'all would not even know what is going on in here if it wasn't for this YouTube channel. If it wasn't for me. Because some of y'all are new. You know what I'm saying? Y'all wouldn't know that these are administrative agencies, that a city is an administrative agency, that a county is an administrative agency, that they corporations, and that they have voluntarily, a long time ago, anywhere from about 100 to 300 years ago, voluntarily made themselves subject to the corporate territorial jurisdiction of the legislature. Y'all wouldn't know that. But here's me reading these cases for you, doing pro bono work, reading these cases for you. Look at this, 45 minutes. Reading this case to you and explaining it to you. Let's go down. The child support thing, even though that's not my book. I didn't do the research on the child support. That's not my book. But me explaining it to you and telling you that your remedy is in equity, because during my spare time I study equity. I didn't get nobody to file no paperwork for me. I study equity. I'll show y'all what I read in a minute in regards to equity if I don't forget. This is me right here preaching to the choir, telling people every American should know this amendment. You should know any type of jurisprudence regarding the Fourth Amendment. You're supposed to know that off the top of your head, because I don't need nothing in regards to probable cause and reasonable suspicion, because I know what it is. Because I've read so many cases on it. So let's go down. What was I talking about? Oh yeah, I was going to show you how I do my legal research. Let's see, right here. This video right here, 25 minutes, me showing you how to do legal research. Good sites. These are the sites that I use in this video to do my legal research. And I read, 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 and I read until I'm just tired and I don't want to read no more. That's what I do. I do research. That's what I do. Extensive research. That's what I do. Unless I feel like I don't need to, because I understand what's going on. Give me a second. Let me get me a drink. All right. This is another video right here. Why is it doing that? Of me doing pro bono work. Just telling you the distinction between an attorney and counsel, because a lot of people want to know that. This is me explaining equity a little bit, the merger of common law and equity courts. This is me doing pro bono work, common law and equity jurisdiction in administrative agency. This is me showing you the maxims of equity. This is me doing pro bono work. This video right here, this video should have 10,000, at least 10,000 views. Y'all, if you haven't seen this video right here, you need to go and watch it. This is me explaining it to you, these administrative agencies, and showing you the cases like I always do. That is all research in this video. That is research that I have collected, or so to speak, over a period of time. What a judge's oath of office look like. This is me doing pro bono work. What a sheriff's bond looks like. This is a real sheriff's bond. I found this online. This is me doing pro bono work. What a judge's bond looks like. This is me doing pro bono work. How to draft a motion. This is me doing pro bono work. How to stop CPS. This worked for me. I can't speak for nobody else, but this worked for me. I drafted this document in this video, and I haven't seen these people again. I haven't seen them again. They haven't been back out to my house yet. This is me explaining how to beat qualified immunity, at least trying to explain it to you, because this stuff takes time. And I don't know what you're not understanding about it, because you're not able to engage me into questioning. But when you do, well, let me stop right there. Let me start on this right quick, and I'll get back to that. But this is me explaining to you it's all about the facts of the case. I don't care if it's a civil case or a criminal case. It's all about the facts of the case, because the facts are the ingredients. The facts are the elements. Let's go down. A bail bond. This is all of these videos that you're looking at that I'm scrolling through. This is me doing pro bono work. That's what this is. So let me go back up just to make sure I didn't leave anything out. And I'll take some questions. There's something else I wanted to comment on too. So let me go to the live section. Okay. Right here. This is our fault part 3. See this number right here? This is me doing pro bono work, because when I come in and I'm live, it's free. If I can answer your question, I'm going to answer your question. If I can't, I'll try. But I can't answer all of the questions, because sometimes this research takes an extremely long time, y'all. Where else we got? Here, right here. This is another one with a call-in number. This is me doing pro bono work. I stayed on 4 hours. This is me doing pro bono work. Here's another one. I apologize for this one. I had the wrong number up, so that's why you couldn't call in that day. I had the wrong number up. But again, this is me doing pro bono work. Teaching people how to sue the police. This is me doing pro bono work. There's another call-in number. This is me doing pro bono work. So I can't teach you privately for free. I'm not going to do that. I'm not going to do that. I don't, again, like I was saying, I don't think that would make me a good teacher. And I don't think that will make you a good student, because the only way that you are going to learn, you're going to have to do this stuff yourself, man. You're going to have to do this stuff yourself. Nobody is going to fight for your rights harder than you. Nobody. That includes me, in my opinion. Nobody. And nobody, in my opinion, knows the facts of your case better than you. Y'all hit that like button for me, if y'all don't mind. Hit that like button for me. And I know I charge for my service. I don't charge all the time. I do stuff behind the scenes and stuff like that. I don't really talk about it, but I do. Let me go to this. So, in regards to 43 Section 1983 lawsuits, I have drafted complaints for people for 42 Section 1983 lawsuits. I do it privately, and it takes time. It takes me anywhere from a week to maybe 3 weeks to get the job done. But that's not free. I'm not doing that free. Just imagine the audacity, like Yusuf say, the unmitigated gall of of somebody, just a complete random stranger, asking you for 7 to 21 days of your time for free, away from your family. Maybe we'll say 8 hours a day away from your family for free. You're not making any so-called money, whatever. How you gonna take care of your family? I just want you to just be reasonable with this. Just think about this. You should not expect something of value in exchange for nothing. You should not do that. He who seeks equity must do equity. All right. So in regards to the 42 Section 1983, this is what I did right here. So about 10 years ago, these videos right here, this seminar was given to me. It was given to me for free. Okay. I'm not selling y'all this seminar. I'm not selling y'all this seminar. I'm giving it to you for free. But you are going to pay me for my time. All right. So if you want this seminar, or if you want to listen to this seminar, what you need to do, just sign up for a membership. It can be $1. I don't care if it's $1. Just sign up for the membership. There's about this seminar is extremely long. There are about 20 videos, and as you can see, they're over an hour long. There's about 20 of them. The guy who did it, a guy named Rick Schramm, and Rick knows what he's talking about. Rick was about 98 to 99% right about almost everything he talked about in that seminar. But nobody taught me this, okay? The terms, the terminology, nobody didn't teach me that. I had to learn that stuff on my own. Man, I had to do the research on my own. I had to comprehend this stuff on my own to the best of my abilities. That's what I did. I guarantee you, if you do that, man, you too will be a supreme litigant. You're going to be a force to be reckoned with in there. All right, but there's about, let me see if I can, I'm going to attach the flash drive to it. All right, and I'm going to show y'all. Is this, that's not it. Okay. Where is it at? Okay, it's called On Point. Oops, I spelled it wrong. On Point right here. This is the seminar. 16, 17, so it's about 17, 18. Okay, so it looks like it is 18 of them. All right, so it's 18 of them, okay? 18. I uploaded 2 yesterday. I'm going to upload 2 more today. You can listen to that seminar as long as it took me anywhere from about 6 to 8 months to understand that stuff. But I just had to I had to listen to this stuff over and 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 over until I got it. And while I was doing that, I was doing the research, reading cases, an extensive amount of cases. Probable cause is a mixed question of law and fact, meaning the facts of the case and the so-called law. In this particular case, we're going to talk about a statute, will always determine if you have been lawfully arrested or unlawfully arrested. Reasonable suspicion is predicated upon specific articulable facts that a crime has been, is being, or is about to be committed. Ignorance of the law is no excuse. Everybody is presumed to know the law. Even though that presumption ain't true, you need to make it true. because these people are, man, they're not going to tell you what your rights are. You can forget about that. But anyway, so I got parts 1 and 2 up today, so I'm gonna do 3 and 4 today. All right, 3 and 4. This is the seminar. Let's see what all he got in here. Look at this, man. This is 5. I haven't looked at this in years because I don't need to anymore. 537 pages. He has his case number on here, everything. Study guide to be used with audio or videotapes. I forgot, so I'm gonna have to give this to y'all too. So if you are a member of my channel and you're listening to the audio, let me know so I can email you this. All right, because I forgot all about it. I'm sorry, y'all. I do apologize for that. This man wrote a brief. This is a brief. Well, not a brief, but it's really a book. It's really an ebook, but it looks like a brief because this is how briefs look too. Forms and complaints. Look at this stuff. This man took an extensive amount of his time to explain this to people. There's a guy who gave me this seminar. His name is Jerry, a little over 10 years ago. So, Jerry, if you're ever listening to this video, thank you. I'm not going to say your last name or where you're from because I respect people's privacy. But all Jerry asked me to do, and Jerry was like, he was probably about 800, maybe 900 miles away from me. But all Jerry asked me to do was to send him a flash drive, which is this flash drive that I just put into my computer. I sent him this flash drive. Send him a flash drive, and I had to pay for a stamp and envelope for it to be returned. And he was gonna just, save everything on a flash drive and give it to me. And that's exactly what I did. He could have. I don't care if he would have charged me for it, depending on how much the price was. If I can afford it, I'm gonna do it. I don't care. I'm gonna do it. He has the cases in here. He cites the cases. This is the seminar that I got that taught me how to sue the police under 42 section 1983. Nobody did not do this for me in regards to drafting the paperwork and understanding the paperwork and reading the cases. The only thing he did was put the information in my face. He explained it a little bit too because he talks about it in the seminar. All right, that's why I'm giving you the seminar free. Now, if you don't want to pay, if you don't want to join the membership, I don't know why, but if you're a supporter of my channel, I don't know why. But anyway, if you don't want to get a $1 membership or whatever, that's fine, that's cool. But you are going to pay me for my time. All right, so what I mean by that is if you don't want to do that, what you can do is you can cash out me, PayPal me, whatever, $3, all right, for my time, just for sending this to you. And what I will do is I'm going to Dropbox it to you. I'm gonna Dropbox this whole file to you. I can't email it because it's too large. I've tried it one time and it won't let me do it. So I'll Dropbox it to you. You are gonna pay me for my time. You're not paying for this. This is not mine. That's why if you go in, if you're a member, that's why you can listen to this stuff straight through, all the way through, because I intentionally chose not to monetize it, because he who seeks equity must do equity, and he who comes into equity must do so with clean hands. This is not mine, so I'm not going to profit off of it. It's not mine, just like this video right here. It's not mine. That's why it's not monetized. Just like Behold the Pale Horse. It's not mine. That's why it's not going to get monetized. This speech, it's not monetized. This video, it's not monetized. Anything that I do not do, I'm not going to monetize it unless the author of it gives me permission to do so. Let's see. Y'all, look, man, if you want to learn how to sue the police, I can't hold your hand, man. I didn't have nobody to hold mine. You're going to have to know this stuff because they going to test you. That's why I'm telling you, you're going to have to do this research and you need to draft your own paperwork yourself. I can show you how to do it and explain it to you, but you're going to have to do it yourself. You need to listen to this seminar. Y'all need to listen to this seminar. This thing was recorded in the 90s. probably I want to say maybe the early or late 90s. And like I just said, I think it was like, what is it, 18 of them? It's 18 of them. All right. You need to listen to this seminar. That's what you need to do, and you need to get a copy of this right here, this PDF file too. I'll email it to you once you what you call it. But how you get a copy of it, or how you want to listen to it, or whatever, I don't care. You join a membership. Join a membership, 99 cents. It's $1. I don't care about that. What else? What else? There may be something I missed. Let me go and check the chat because I haven't even checked. I don't even know if anybody's watching this early or not. Hopefully y'all can hear me. Let me go and check this chat. Well, I'm gonna click on here and I'll just turn the volume down. We'll do it like that. All right. I appreciate that, folks. I really do. Thank you. I really do. Yeah, I turned it down. Okay. Everything you put out on this channel is pro bono. Thank you. So I really appreciate that. I really do. How can we expect to get remedy from people who struggle? Oh boy, that's funny. That's funny. I don't think that has anything to do with it, but I do get what you're saying. Um, these people, they just crazy, fam. They Jr. I don't know if I think it's Jr. I'm not really sure, but I think there's somebody who's litigating a case by themselves, pro se. I think it's a 42 section 1983 lawsuit. He'll tell you if you know what you're doing, man. Man, they just haters, man. They haters. I don't know what else to tell y'all. They haters. I don't know what else to tell you. They just haters. Um, let me I'm about to do some more pro bono work. This video right here, this is pro bono. This is not mine. To be honest with y'all, like I had this information and I forgot that I had it. And so I'm like, man, I need to put this stuff out because it's not on YouTube anymore. They took it down. This video right here, Carl Miller. This is the first. This is where I got started to learn my rights at right here, right here. This guy right here. I think he's deceased right now. I put out, in my opinion, great content because I show you the cases. You cannot cite any case on my channel that I cite and say this case doesn't say that either it doesn't say that expressly or it doesn't say that implicitly. You can't do it because I do my research. I do my research, man. Um, so I'm gonna start back here, and let me go back to the community section on my channel. All right. This is me explaining. I'm like, look, I have done 2 to 3 videos months ago that show you how to draft motions. However, if the videos are not beneficial to you, register for my 6-day, 18-hour draft class starting Monday, May 20th. Now, yeah, I think that's Monday, May 20th, 2024 at 7 p.m. Central Standard Time. See the fire below for details. Blah, blah, blah. All right. I have 22 people right here. 22. If y'all want to learn how to draft motions, then you need to register for this course. You can have one-on-one time with me. We will research cases. I will explain this stuff to you to the best of my abilities. Drafting all of this paperwork is easy. That's only half of it. The other half, I cannot do it for you. You're going to have to do it. You're going to have to read. I don't know what else to tell you. I don't know what else to tell you. You're going to have to read. You're going to have to read. Where's the where I don't even know how to do this. Am I doing this right? Right here. Okay. All right, I'm back. Got it. Got it. Okay, cool. All right. Again, focus. Thank you for joining. It's 99 cents. Thank you for joining. I'll upload some more of those videos today. Once I finish this video, I'm not gonna be on here long. I only anticipated doing maybe probably about an hour just to explain this stuff to people. Um, I think I'm worth that. Okay, like I said earlier, I think I'm worth more, but I know some people just can't afford this stuff. This stuff is extremely expensive. Um, will it be recorded and passed out to the class? If you're talking about the to how to draft a motion, stuff like that, it's going to be recorded. It's not going to be passed out because it's going to be live. You see what I'm saying? It's going to be live. But what I can do, I think I understand what you're saying. Um, and I think the equitable thing to do, in my opinion, um, like if you actually attend the class or something like that, and you have questions, because you're probably going to forget some stuff, and you're going to want a copy of the video or something like that. So I think to all people who actually register for the course, I'll just let them have that the videos or whatever. But if you did not sign up for the course or anything like that, the courses it will be for sale. That's going to be for sale. Or I might just put it on YouTube and monetize it. Well, you know what? I'm not going to do that because there may be some people in there who don't want their privacy put out like that, so I'm not gonna do that. I'll just sell it privately. I'm not gonna put it on YouTube. Yeah. He sees Robert in the class. Will you do a Zoom recording and will you or have you PDF files for shadow emotions to fill out for the class? Something generally speaking, yeah. But let me show you something, Robert. So we can go and re-listen. Yes, okay. Yeah, I see what you're saying, Focus. So yeah, I agree with that. That's a good idea. I actually didn't even think about that. Thank you for that. That's a great idea. But if you register for the course and you sign up for, I'll just give y'all that. You know what I'm saying? But let me show you some, Robert. I'm gonna pull up the book. I gotta go to my email and get it for you. This ain't my email. What am I doing? I forgot what my email. Let me pull up my email and I'm gonna show you. What's my email? Is it Google? Is it? Yeah, I think it's Google. Gmail. Okay. I forgot the name of the book. I think it's DC. I'm just gonna put DC. I think this is it. I'm not gonna give y'all her email address, but this is a woman who lives in DC. Okay. She never asked for this ebook. Okay. She never asked for it. But as soon as I finished drafting this ebook, I emailed her a free copy of this ebook just to help her out. She never paid for it and she never asked for it. But let me show y'all the ebook. This is the 42 section 1983 ebook that I did. I need to download. Let me just download this because I just be tripping. So now save it on my computer because I don't have it saved on this computer. I have it saved on my other computer. All right. Oh, by the way, if y'all don't want to call me the Supreme Litigant or something like that, this is the name that I lawfully changed my name to, Amir to Amari, right here. So y'all can just call me Amir R2, whatever you want to call it. It doesn't matter. But this is the ebook that I did. All right, explaining this stuff to people. I put sample discovery. It's not a motion, but request for admissions, request for productions, interrogatories, sample objections, sample initial disclosures, sample motions, motions for leave of court, motion for an enlargement of time, motion to strike, motion for summary judgment, motion for a more definite statement. And then I put a case synopsis in here. And I also put a sample complaint in here. And I'm going to show you this stuff. Let's go to the sample forms. Well, let me stop. Let me stop. I put I went and did a little bit more research on it because I really be wanting people to understand this stuff. So like for example, what is probable cause? And I just told y'all this verbatim without even looking at it because I've read it so many times in cases. Probable cause is a mixed question of one, law and fact, two, fact. Hold on, somebody. I don't know who that is, but meaning one, the facts upon which a police officer concludes that you have allegedly violated a statute, and two, the elements, i.e., intentionally, willfully, negligently, knowingly, etc., of that particular statute will always determine if there was probable cause, i.e., if you have been lawfully or unlawfully arrested. I almost just said that verbatim without even reading this stuff in this ebook because I've read it so many times. Whether probable cause exists depends upon the reasonable conclusion to be drawn from the facts known to the arresting officer at the time of the arrest. And there's the case right there. And if you go on what is it at 148 on this case right here, you'll see that. Probable cause depends upon whether at the moment the arrest was made, the facts and circumstances within the arresting officer's knowledge and of which they had reasonable trustworthy information were sufficient to warrant a prudent man in believing that the suspect had committed or was committing an offense. Same thing. All right, but they're not operating under common law jurisdiction. Meaning, for example, police officers are not created under under common law. That's only the sheriff. He's a statutory officer. So he gets all of his authority from a statute. And so, since this is not a common law police officer and they're not trying this case under common law jurisdiction, the statute, what they are doing, y'all, I know y'all probably heard me say this, but if you didn't, what they are doing is, well, what they have done is, they have codified common law crimes from the jurisdiction of common law where they have no control and brought it over into their jurisdiction where they have all the control. That's what they did. That's why it's always going to be a statute. That's why you're dealing with colorable courts, colorable law, and colorable money. Federal Reserve notes are not money. Administrative agencies have zero judicial authority, and statutes are not laws. This is me right now. What I'm doing right now is pro bono work. This is pro bono work. Look at this. All of the footnotes in here with the cases. I've already done the research. It's nothing for me to go and read the case. Okay, yeah, that judge is right. Copy and paste that and put it in here because he's right. He's right. Or maybe if I think he's wrong, probably just explain it to you a little bit better or something like that if I feel like it needs to be explained. But I do that as well. And then I do this. The procedure to secure an arrest warrant and conviction. This is something I'm just explaining this to you. It works like this. When a police officer files a complaint against your legal person via a statute, because we're not under common law jurisdiction, so they're going to be using statutes. She or he must allege one, facts that show your legal person violated that statute, and allege that your legal person committed an offense prohibited by that statute. The magistrate then ensures that the police officer in making that charge against your legal person under oath and the complaint is factually sufficient, meaning it is legally sufficient to justify why they're doing what they're doing to you, or in other words, i.e., that there was probable cause to issue an arrest warrant for the seizure of your legal person. The judge then 5 interprets that statute, and then 6 applies the relevant case law to that set of facts alleged by the police officer to determine if you were guilty or not guilty. It's always about the facts. That's how they do it. That's how they do it on the criminal side, and that's how they do it on the civil side. All right, chapter 4. This ebook is for the District of Columbia, but generally, I mean, it's pretty much gonna be the same everywhere, y'all. Where are we at? All right, addendum. So these are the copies of the motions, Robert. So this is a plaintiff's request for admissions. So this is how a request for admissions look. See how simple this is? But I like to make my stuff detailed. This is me doing pro bono work because I don't have to do this. All right, but I know that people sometimes what I ain't gonna say sometimes, but generally speaking, people pay attention to details. Well, at least I do. So I take back generally, but I pay attention to details. So what I do is this right here. I highlight this. I bold this. All right, and I bold this here. So if you go to Rule 36A 1A of the Federal Rules of Civil Procedure, that is the authority for requests for admissions. That's why I have this footnote right here. See that? That's 67. If you scroll down to 67 and read it, here's the case right here. Federal Rule of Civil Procedure 36A1 permits a party to serve upon any other party a written request to admit the truth of any matters within the scope of discovery. The opposing party then has 30 days to admit, deny, or state in detail why it cannot fully admit or deny or to object to a request for admission. Blah, blah, blah. This is me doing pro bono work. This is me doing pro bono work. This is me doing pro bono work right now in this video. Certificate of service, blah, blah, blah. That's only one. All right. Here's another one. Plaintiff's request for production. The reason why I do this stuff like this is because I want y'all to see how simple this stuff is. That's why I do this. There's another footnote right there. If you go down there and read that footnote, there's going to be a case down there. Okay, I don't have to do this. Attorneys don't even do this. They don't do any of their paperwork, generally speaking. The paralegals do all their work. Nobody does my work. I do all of my paperwork. Everything. Nobody drafts nothing for me. Let's see. And this is just sample. Me giving you examples of how this stuff is supposed to look. What else I got in here? You always got to have your certificate of service in there, all right? So you're going to always see that. This is me doing interrogatories. I have sample interrogatories in here. All right, another footnote right there. You go down, you see that footnote. There's going to be a case in D.C. from the federal D.C. U.S. District Court, D.C., explaining it to you a little bit. But you see how all this right here, see how all that looks the same? Only thing you're going to be changing is this. And probably, change your footnote or whatever. You might not want to do your paperwork like this. You might want to do it a little different. All right. There's some stuff I want to show y'all, but I can't because I'm still litigating the case. I'm saying that I have some haters on my channel, and I reasonably believe that they will go back and find out. Because if I make this stuff public, I believe that they will go and tell these attorneys and stuff like that. Hey, this is the guy who's helping so and so. I'm not gonna do that. We're not doing that. This thing has gotten cold. Give me a second, y'all. I'll be right back. It's supposed to be hot. All right, all right. Y'all make sure y'all hit that like button for me too. All right, Robert. If you're looking, Robert, I know you said you don't really get a chance to catch the lives, and this was just random, but I felt like I had to address this issue, and just explain this stuff, explain myself or whatever. Plaintiff's objections to defendant's exhibits. You know what I'm saying? See how simple this stuff is. See how all of it looks the same. You just explain to the court what you're doing. But you're not going to see me write the grounds. That stuff will take forever. I'm not going to do that. I'm not doing that. That will take for. I'm not doing that for free. Put it like that. That will take forever. This stuff takes time, y'all. Prayer for relief, blah, blah, blah. Just explain this to you. Comes now, John Doe, hereinafter plaintiff, pursuant to Rule 402 of the Federal Rules of Evidence. Pay attention. Evidence, not rules of procedure, evidence. Because the Federal Rules of Evidence governs the admissibility or inadmissibility of evidence. Objecting to defendant's exhibit 1, 2, 3 as irrelevant. Why am I saying it's irrelevant? Well, you got to explain it. Why is it irrelevant? If it's irrelevant, it's got to be excluded. Why does it have to be excluded? Because under Rule 402, only relevant evidence is admissible. If it's irrelevant, it's inadmissible. All right. Plaintiff's initial disclosure, something like this. You see what I'm saying? Just simple stuff. See how it looks like you're looking at the same document over and over, because all this stuff looks the same. It's all the same. This is me doing pro bono work. I know that's probably pissing some of y'all off when I say that, but I'm gonna keep saying it. Footnote right there. I don't have to do that. I do this, to show you the details so you can pay attention, so you can go and read this stuff for yourself. A motion for leave of court. You might want to file a motion for leave of court because your complaint is, it just doesn't have enough merit. You haven't pled enough facts. You haven't added enough ingredients that the so-called judge can use and to make reasonable inferences, aka reasonable conclusions from, in support of your case. So you might want to file a motion for leave of court. I have that in here for you. And it's okay if that's what you have to do. Plaintiff's motion for an enlargement of time. You may need more time to respond to some of their gobbledygook. That's what they like to call your stuff, gobbledygook. They don't call my stuff gobbledygook. I ain't gonna let them do that. But they will file some shotgun pleadings. I'm telling you what I know. I actually have that in this book, where an attorney in this ebook right here, it's up in chapter 4 regarding shotgun pleadings, where an attorney kept filing shotgun pleadings in court and he got sanctioned for it. Like he should have. He should have been sanctioned for it. He kept filing shotgun pleading. What are you doing? Like, how long you been an attorney? Anyway, enlargement of time. So if you go to, I'm gonna just show you what I'm talking about. Let me show you what I'm talking about. So we're gonna go to Rule 6B1 of the Federal Rules of Civil Procedure. Let's go to Google. We're gonna say Federal Rules of Civil Procedure. All right, we're gonna go here because I've already been here. I'm gonna go to Rule 6, computing and extending time for motion papers. And what rule was that again, just to be sure? It is 6B1. So let's see what Rule 6, we're at 6. That's A, so we got to scroll down. B1 says, when an act may or must be done within a specified time, the court may, for good cause, extend the time. All right. So to file this motion, in support of the motion, plaintiff avers the following grounds. State your grounds for filing the motion. But how are you going to know what to say? You have to read cases. I'm not going to do that. I'm not going to put all that stuff in here because the facts of the case, they may be different. You may be going out of town. You may be going to a funeral. You may be working extremely unreasonably long hours at work or something like that. I don't know what it is. A car might have hit your power line outside. You don't have any power. You see what I'm saying? So you can't work on the case. It can be anything. I'm not going to do that. You need to y'all need to man up and woman up and let these people know that you're not scared of them, and you need to litigate your case. You need to know what your rights are. Motion to strike. Motion for summary judgment. This right here, I'm definitely not finna do that. No, ma'am. No, ma'am. No, sir. No, ma'am. I'm never going to do a motion for summary judgment for free for pro bono. I'm never doing that. That is the longest motion ever. I'm not doing that. And I ain't never did one, but I just know the procedure that you have to go through to do it. I've never done a motion for summary judgment, but I know it's long because I've had a motion for summary judgment served on me. And I'm like, man, this is long. I didn't tell how long it took them to do this. You see what I'm saying? I know the procedure that you have to go through to properly do it, and it's long. Can I do it? Yes, I can do it. I can do anything. Motion for a more definite statement from when they file a shotgun answer. When they file an answer, it's so vague and you don't know what they talking about. It's just all over the place. You file a motion for a definite statement under Rule 12E, Federal Rule of Civil Procedure. Let's go and see what that say. Rule 12E. This is me doing pro bono work. This is how you litigate a case. E. Motion for more definite statement. Let's make sure we got that right. Rule 12E of the Federal Rule of Civil Procedure. Okay. A party may move for a more definite statement of a pleading to which a responsive pleading is allowed, but which is so vague or ambiguous that a party cannot reasonably prepare a response. So on and so forth, blah, blah, blah. And I just told y'all about the motion to strike. That's a Rule 12F motion. So if you not, don't get me wrong, I understand if you're hesitant with giving me $200 if you don't know me. I respect that, and I completely understand that because there are scammers out here, and they will scam you, fam, and they will block you, and they will say that you're lying. They will do that. But I am not that man or woman. All right. He who seeks equity must do equity, and he who comes into equity must do so with clean hands. Equity will make a saint out of you. So you need to practice equity. I have a case synopsis in here where I'm just explaining this stuff to you. See this? Just explaining it to you. This is not in the original ebook that I drafted because I was just trying to put something together just to hurry up and get this out there just to try to explain it to people. All right, but I took my time with this one. If I keep doing these ebook series, the prices are going to be different because the District of Columbia, I mean, they only have one jurisdiction, which is DC, that I know of. But like if I go to the 11th Circuit, for example, they have Alabama, Georgia, and Florida. That is 3 different states, 3 different laws. Yeah, that stuff will take. Is this making sense for y'all? Of how, just give you an idea of how much time it would take for me to do it? It makes sense to me. Man, I'm getting hungry, y'all. Let me go and check the chat right quick. I'm sorry. Let me check the chat. Will it be record? Okay, yeah, I think I did that. You're welcome. Yeah, okay. I'm in for class. On archive, there is a 42 section 1983 book, but none downloadable. I did find a book on the supremacy clause on eBay from archive, and $140 is insane. The ebook. They always try to do a 12B6 on you. They ain't gonna never do no 12B6 on me. Not me. Not unless they want to lose. No, and that's no disrespect to you, folks, because you are right. But oh wow, you're on again. I know one wire that I know. How long is the class for, Rob? Okay, if you're talking about the just how to draft a motion class, the motion class, it'll be for 2 weeks, but obviously it's not going to be for 14 days. It's going to be for 6 days. It'll be Monday, Wednesday and Friday, starting May 20th. That's just to give y'all some time to come up with it. You know what I'm saying? Because I didn't want to just make it so soon. But it'll be a 3-hour class, and I'm only taking 10 people because I know, in my opinion, it is quality over quantity for me. I'm actually trying to teach you this stuff, but I don't know how to. I can't give you answers to questions that you don't ask because I don't know what to say. You know what I'm saying? So that's why I'm doing this. It'll be on Zoom. And if you need to make installment payments, that's fine. All right. I accept Cash App, but y'all gonna have to pay the transaction fee. Okay. I think Cash App might have charged 2.5% or something like that. I'm not sure what PayPal charges, but I recommend you do it through, you send your payment through Zelle. If you want to do Zelle, Zelle is free. Um, I'll send you my like a payment request or something like that for Zelle. But altogether, the class will be 18 hours. It'll be 3 hours every class period. I think that's enough time. Let me I'm gonna go and explain the rule 12B 6 to you if I can focus. I'm gonna try to do that right now. This is me doing pro bono work, by the way. Let me go to the rule 12B6 right now. Should be up here. All right, so this is rule 12. We're gonna go to rule 12. That's A right there. So you got to scroll down to 6. B. All right, so we're going to go to subsection 6 within this rule. Failure to state a claim upon which relief can be granted. All right, if your complaint is meritless, then of course they're going to file a Rule 12B6 motion to dismiss. All right, so what do I mean by that? So let's say a police officer arrests you, all right, and he say that you unlawfully, he say that you resisted arrest, all right. But if you look in the complaint doesn't have any facts in which it allows him to reasonably conclude that you did resist arrest. So how would you answer that? You would file a Rule 12B6 motion to dismiss, even though this is on the criminal side or whatever. So you're not going to say Rule 12B. You're not going to say that. You're just going to file a demur. You're going to motion to dismiss. A demur is an antiquated word for a motion to dismiss. All right. Why are you going to do that? Because it fails to state a claim upon which relief can be granted. They're filing a lawsuit against you. All this stuff is an insurance claim. On the civil side, it's an insurance claim. On the so-called criminal side, it's the same thing, but obviously they're not going to make this that obvious for you. This is about money. So let me go in and I'm going to explain it to you again. I did a video on this now, just to let you know. The video, I think I did 2 videos on it called It's All About the Facts, and where I show what these police officers do, because they just idiots. They don't know what they're doing. What they'll do is they will copy and paste the words in the statute and put it in the complaint. You can't do that. They violate due process when they do that, because how am I going to dispute an unstated allegation? You're not making the allegations against you. You're not making any factual allegations against me. So how can I dispute them? I don't know what you're arguing. You're not giving me due process. You're violating my due process rights. So let me go and explain this to you. What is that website? Oh, Case Text. Let me go to Case Text, and I'm gonna explain it to you. What is this? On Point? Yeah. All right. So we're gonna go to Case Text right quick. Okay. How can I word this? What is it? All right. We'll say devoid of the prerequisite elements of the offense. And I'm gonna explain this to you. It's the same thing, y'all. It's the same exact thing. You cannot file a lawsuit against the police saying they unlawfully arrested you without the facts
demonstrating, showing, explaining to the judge, so-called judge, so that they can reasonably conclude that you were unlawfully arrested. You cannot do that without the facts showing that, because you too violate due process when you do that. That's why they're going to file a motion to dismiss, because they're saying that these, whatever these is, these facts are legally insufficient to justify suing this police officer. That's why you do that. It's the same thing. Let's see. I'm trying to see. In Cotton, the court held that an indictment containing the essential elements of the offense is not a jurisdictional prerequisite to a criminal prosecution. Okay, we getting there. Under the law, it is not necessary to state all the constituent elements of the crime charged. We're getting there. We'll get there. The record is devoid of any description of the crime charge or any diversement. Essential elements. The essential elements of that crime were lacking. I'm gonna see if I can find it, and it might be in that case from 1942. There was nothing in the record to show the compounding of a felony. The essential elements, the ingredients of that crime were lacking. The instruction by the judge that the repayment of the money would not affect the crime. Let me see. It follows that the essential elements of the crime charge are wanting. The only things necessary to allege an offense are the elements of an offense. They're right. They're 100% right about that. The elements of the offense. What facts do you have? I'm trying to see if I can find a case that explains this. I wonder, can I pull up my case? Well, no, it's not on this computer. It's on this computer right here. It's not on that one. The statute does not even set forth all the essential elements of the offense. Okay, I'm gonna do it like this. Conclusory criminal complaint. That might work. Let's see if that'll work. Although a complaint, let me see, the procedure, the complaint is the basic charging document. A complaint forms the essential basis for invoking the trial court's jurisdiction. Yeah, that's true, especially if it's an administrative court. Although a complaint need not state all the specific facts that would sustain the charge, it must contain all the elements of the charged offense. Let me see if I can explain that a little bit more. You see how the time that it takes for me to try to find the right case to just try to explain this to people. Thus, although in a general and specific factual acts underlying the elements need not be specific, the complaint must conclusory criminal complaint. I might got too much in there. Devoid elements of defense. We're gonna say dismiss. That might help. I spelled dismiss wrong. Ooh. Spelled it wrong. Let's see if this will help. It is a fundamental rule of criminal pleading that a complaint which does not set forth the nature and elements, the elements, when they say elements, they're talking about the facts of the crime sought to be charged, fails to state an offense and is subject to dismissal. A complaint that fails to allege every fact, aka element, necessary to constitute the offense charged is defective. So what do you do when it's defective? You motion to dismiss because it is legally insufficient as a matter of law. So what you're saying is, based on these facts, the law has said that these facts do not constitute disorderly conduct. Is that making sense? Does that make sense? They not smarter than you, fam. They not smarter than you, fam. You just got to read. This is me doing pro bono work. So if you curious to want to know if I know what I'm doing, this is me doing pro bono work. Give me a second, y'all. I'll be right back. Uh, Let me see. I don't. Let me. I'm just now checking the chat, y'all. I'm sorry. Let me check. Read some of the comments. Did you receive my payment for the jury membership? I have a Google temporary hold on my debit card and holds it from you. Probably so. I don't know. But just thank you for trying because I really appreciate it. Robert, have you ever filed a writ of right for anyone? Let me see what a writ of right is. See how I just admitted that I didn't know what a writ of right was? He who seeks equity must do equity, and he who comes into equity must do so with clean hands. I don't know what a writ of right is, so let me go and see because I might know what it is. They may just call it something else. So let's go to Google. We're gonna see. We'll see what it is. Writ of right. Let's see what a common law writ for the restoring to its owner property held by another. No, I haven't done one, but if you want to know, can I do one? Yeah, I can. As long as I have to find out what the elements are to to know what facts to plead, to know if you have if that is the appropriate remedy for you. But you probably don't even need to do that. You can probably do well, no, they already see if they already seized the property, then you probably would have to do a writ of right if they already have possession of the property. So yeah, you probably would have to. Or I was gonna say a mandate, not a mandamus. Can't get no injunction. So you're trying to get possession of the property back, if I'm not mistaken, and probably get legal title to it or something like that, if I'm not mistaken. Um, you can too, one wise lady. I'm not the only one. You can too. Once you understand how simple this stuff is, man, this stuff's so simple, y'all. When you use PayPal to send another, always hit the gift, family, friend, or friend, so there's no fee. Oh, see, I forgot all about that. I forgot all about that. That's good advice, focus. But now, if you want to, if you're trying to make a purchase or something like that, and you want your purchase secured, then I wouldn't do that. If you want your purchase secured, Robert called for a warrant when police throw mud at a wall and see what sticks. Called for don't think I used the PayPal option. Let me see, is it like a list of allegations? All right, when you say a list of allegations, what do you mean, one wise lady? You mean like the facts in the complaint that they have to plead or something like that? Is that what you're talking about? Brandon from one has an awesome example on his other web page that he's currently doing regarding negotiable instruments in real time. Yeah, I know you're talking about, Brandon. I know you're talking about. Parrott versus Taylor, interesting case I found. Also, another was Cherokee versus Georgia. All right, a case. Okay, it's the same thing, one wise lady. It's all about the facts. When I say fact, they're really just making allegations. All right, so let me explain that to y'all. When they file this lawsuit against you in the so-called criminal case or whatever, they're essentially just making allegations first. All right, then they have to go through what they call discovery. All right, so when you file your motion for discovery, they have to disclose to you every piece of evidence that they are intending to use against you. If they do not, especially if it's exculpatory evidence, meaning evidence tending to show that you're not guilty, if they do not disclose that evidence to you, that is a due process violation. I think it's a Brady violation, I think. So right now you're just making the allegations. Allegations, I mean, an allegation is really a claim. That's what it is, one wise lady. It's the same thing. So that's how it works on the criminal side. So let's talk about the civil side. So on the civil side, all you're doing, unless you already have the evidence, all you're doing is making allegations against them. That's all you're doing. And the judge, so-called judge, is going to review your complaint to see if these allegations show that these police officers violated a clearly established right of which a reasonable officer would have known. In other words, he's going to determine if these officers acted reasonably under the facts and circumstances. If they acted unreasonably, meaning they acted unlawfully, then at that point in particular time, they're not going to be entitled to qualified immunity. All you're doing is just making a claim that they violated your rights. After that, then you go through discovery to prove your insurance claim, because it's an insurance claim at that point. They had an insurance adjuster at my settlements conference. Does this work in an equity court? You mean like in regards to pleading the allegations? Is that what you're saying? If that's what you're saying, that is a great question, and yes, ma'am, it does. See how you knew that, but you just wasn't sure? See what I'm saying? It's the same thing. Everything is about the facts. If you're in an equity court, you need to plead facts to show that the defendant violated principles of equity. And you need to make sure when you plead your facts showing that you did not also violate any principles of equity. Why do you need to do that? Because he who seeks equity must do equity, and he who comes into equity must do so with clean hands. That means zero fault. This is me doing pro bono work. I haven't even eaten breakfast yet. Actually, I'm here longer than what I anticipated to be. I'm gonna try to get out of here in about 10 minutes. You can read some more of these comments. Yes. Exposing, sorry. What do you mean? Let me see. What do you mean exposing? One wise lady. It's all the same thing, y'all. All of this stuff is the same thing. You cannot plead conclusory, you cannot make conclusory allegations in support of any of your claims. So what do I mean by conclusory allegations? Let me go and show you what I mean by conclusory allegations. Let me scroll over here into my ebook. First, let me show y'all the complaint first, because I did do a sample 42 section 1983 complaint with the causes of actions and so on and so forth like that. All right, now let me scroll. I just wanted to show y'all that. Let me scroll up and show y'all what I mean by conclusory. You can't do that. I think it's going to be in chapter 4 in regards to shotgun pleadings. Let's see. Complaints of shotgun. I'm getting hungry. I got to get me something to eat. Here it is right here. It's footnote 61. Let me make this bigger for people who can't see. Excuse me. Conclusory. Expressing a factual inference, or in other words, a factual conclusion, without stating the underlying facts on which the conclusion is based or inference is based. We're going to use conclusion because I think that better explains it. All right. You can't do that. In any case, you violate due process when you do that. You can't do that. I don't care if it's just like you can't do it in a civil case. What makes you think they can do it in a criminal case? You have more rights attached at a criminal administrative hearing than you do in a civil one. So what makes y'all think that they can do that in a criminal case? Because they can't do that. They gonna try it, and they do it. They do it. They do it a lot because you don't know. You don't know this stuff. You don't know it. Let's get back to the chat, and then I'm gonna get on up out of here. Uh, yeah, it really is, Burn. It really is. That's why I mean that. Also, like it's not my information in that video. I'm not gonna monetize that. That's why you should be able to watch that video all the way through because it's not my material. So I'm not gonna monetize that. I don't just do this for money, man. I keep trying to tell people this stuff, man. Um, let's see. I did file for a bond oath on a sheriff retired and a detective sold their house over what they did. So paperwork does work when they run scared. Yeah, it works. If you know what you're doing, yeah, it do. It means little when you're going into their administrative tribunals constitution. Well, I can understand why you would say that, but even though I disagree, but I do understand why you say that because they literally think and they act like they can do whatever they want to do, and they'll call you a sovereign citizen and all this stuff. Now you got people in the courtroom looking at you like you crazy. Whole time these people are committing treason, and they not even judges because they don't even have any judicial authority at all. They don't have any judicial authority in any administrative agency. They don't have it because of separation of powers. So if they don't have judicial authority, what authority do they? What are they doing? That's why they call it quasi judicial authority. Yes, that's my ebook, but that's the one for the DC circuit. Let me see. You should go on Telegram. There's a group with over 75,000 members. I gave your link on here to the owner if that was okay. Yeah, that's fine. I appreciate it. That's fine. Uh oh, it's okay. Um let me see. Well, the jury, I'm gonna go to it and show you right quick, SG. Give me a second. The C word is a dirty word these days because unless you're in the high court, they throw you out. I don't know what the C word is. I guess citizen, I don't know. Yeah, no ads in the video. That's over 5 hours, so great. I appreciate it. And how did you get that video to begin with? I think I got it off YouTube, Burn. I think I did. I can't really remember, but I think I got it off YouTube, and I felt like people should have. I feel like people need to know that information. Um, Let me go and explain the juror membership right quick. Oh, the Constitution. Oh, okay, I got you. That's funny right there. I got you. All right. The perks for the juror membership. I don't even remember what the perks were. Let me go and see. Probably just a shout out, or probably just priority comments or something like that. Um, and I'm getting hungry. I gotta get up off here, y'all. I'm hungry. I don't even know what the perks. What are the perks? I don't know. I think it's just like I think it's just priority comments or something like that because um I do answer questions of people who are actual members of my channel before I answer other people's questions. Sometimes I don't answer other people's questions at all. Um, I don't do that intentionally, but sometimes I do it intentionally. I'm not gonna lie, but I don't do it all the time intentionally. I just be forgetting. um, where? Oh, I got a little headache. Let me go back. Fair enough. Um, yeah, yeah. Back to David. Yeah, that's the ebook, David. Um, Let me get off here. 'Cause I got a headache. I wasn't even supposed to be on here that long. You were talking about a study guide and a video. Oh yeah, you're right, SG. Okay. I forgot SG. I completely forgot. All right, let me go back to that right quick. So let me click off here. Where was videos right here? Okay, this seminar right here. All right, thank you for that, SG, because I completely forgot, man. Y'all register, sign up for a membership, 99 cents. I don't care. Sign up, whichever one you want, whichever. I just want people to show me that they actually do value my time, based off the information that I provide. But this is part one and part two. Let me go back to the ebook. Let me go back to it or whatever. But once I get off here, I'm gonna upload parts three, which is right here, in part four today. All right, this stuff I believe this is over. It's probably close to 30 hours long altogether. All right, with the study material, which is right here, this right here. You will have access to that for free. None of this stuff is monetized because it's not mine. Okay, it's not mine. It's not going to be monetized. All right, or if you don't want to give me $1, you know, you can cash out me, PayPal me, whatever, $3. You're going to pay me for my time, okay? Pay me $3 or whatever, and I will send you everything that I just showed you, which is all of this entire seminar. I will send it to you in a Dropbox. All right, something like that. I can't. I don't think I can email it. I've tried to email it. The file is too big because, like I said, this stuff is over like probably I think it's over at least 30 hours or at least 30 hours long altogether. That's what I'll do for all the juror memberships. Whatever. Uh let's see. Like I have 2,050 subscribers on my channel. And I think I have like maybe one or two juror membership. Not one or two, I'm sorry. I probably have about 9 right now because I think somebody else just joined today. Joined today. Whew. And then look, I don't even get the whole dollar, y'all. I get 70 cents. I get 70 cents. But I know that there are some people who actually do want to support my channel, but they just don't have the funds or whatever. Because what y'all probably don't know this, but when I get so-called paid for this allows me to not focus on worrying about paying my bills, not going out into the free world trying to so-called make some money. I can just do research all day, and when I find some stuff that's good, I can come back and show y'all this research. That's why I'm asking for these donations, or that's why I'm asking for you to join the membership, because I can do some great legal research. I don't mean to sound like I'm begging or anything like that, because you don't have to support me. You know what I'm saying? I can't nobody force you to to support them. But I'm just asking, like, if you value this information, please respect my time that I go through and that I spend to provide you this information by asking for donations. He who seeks equity must do equity, and he who comes into equity must do so with clean hands. You should not expect something of value in exchange for nothing, unless whoever is giving you something of value is okay with it. I'm not okay with that. Not all the time. Sometimes I am, but not all the time. I hope I explained that to you good enough, SG. I'm not really sure if I did, but there's a I'm gonna upload all of these on here over a period of time. All right. And you just listen to it over and over and over and over and over because that's how long it's gonna take you to get it. This is the material that I got that taught me how to sue the police. And I had to study. I had to go and do my research, man. I had to. I'm gonna show y'all some more stuff in there too, because he has his case file in there too. Now, I typically do not believe everything that is on a court's docket. Man, the reason why I say that is because I know that these people are corrupt, and there's just certain stuff that they do not want on the docket, and they will do whatever they can to prevent it from being on the docket, especially if it's a pro se litigant. So let's go down. He has these are all the cases right here. Let me go down because I'm trying to show you some of the actual documents. Is that it? No. This man did his research. This is how you do research. You got to go and read this stuff, man. Somebody hold your hand, man. Summary judgment, qualified immunity. Plaintiff brought this action pursuant to 42 Section 1983, alleging that defendant police officers and paramedics failed to properly screen Daniel Walson, whatever, for suicidal tendencies prior to incarcerating him. Something like that. Okay, let's go down. I think I got to go to about 200 maybe. Trying to find his he has a copy of his complaint in here too. Is it 300? I don't know. It's a lot of pages in here, y'all. Cool. And this information, this is for anybody who signs up for a membership. All right. And if you don't want to join the membership, just cash out me $3, like I said, send it PayPal or Zelle or whatever, and I'll Dropbox it to you. Or if you're not comfortable with that, or if you don't have a Dropbox, send me a well, now because I'm not really giving out my address like that. What else? Send we'll not Dropbox, Google Drive, or just something. Or I might just get a PO box. I'll go out and get a PO box, and I'll tell y'all to send it to that PO box or something like that. And no offense, y'all, but I just value my privacy. Um, Even though some is just probably I got an address somewhere on here. I don't know. Where is this paperwork? I know it's in here because I've seen it. Even though this was like 10 years, it's been an extremely long time since I looked at this. This man got everything in here that you need. Everything that you need. Sample complaint. Look at this. Answer, admissions, denial, lack of knowledge. These are sample. This is what this is right here. This is a sample answer to a complaint, because this is how they answer a complaint. Comes now the defendant, blah blah blah, and for his or her answer to the complaint of plaintiff alleges and states that blah blah blah, defendant is without knowledge and information sufficient to form a belief as to the allegation contained in paragraph blah blah blah, and therefore denies same and demands strict proof thereof. I've seen this before. Not this document. I've seen this in attorneys' answers to my complaints. These people not smarter than y'all, man. They got all this stuff written out for them, man. They just read. That's it. Count one, denial of right to freedom of speech. Plaintiff avers that the action taken under color of law by defendant blah 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 was an unconstitutional prior restraint on plaintiff's First Amendment blah blah blah. The plaintiff has incurred attorney's fees blah 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 blah. Look, this must be a sample complaint right here. One of them's got to be facts. Oh yeah, it looks like it's a little out of order. Is it out of order? Yeah, it is out of order. Okay. Facts on or about this. This is how a sample complaint looks, y'all. This is how it looks. But what I'm going to I think I go a little bit more in detail, or I'm not trying to say I'm better than the guy who gave me this information, the guy who taught this seminar, okay? But I do believe that I like, as of my time of just studying this stuff, I am more advanced with this stuff. But I am grateful for this information because I don't think I would have learned it without it. Not on my own like that, because he just had everything in one place that I needed. You know what I'm saying? allegations and complaint, denial of property interest without due process. Look at that. This man did his research, man. This man went down to the law library, man. And when you hear, he's gonna tell you why he sued these people. When you hear why he sued them, it's going to just shock you. He should have sued them. I'm not gonna tell you why, but you need to go and listen. He should have sued them because they had no business. They had no business doing that. Look at this sample complaint right here for you. Complaint, jurisdiction, and venue. Amount in controversy exceeds $50,000. That's how you know this is old, because the amount in controversy now has to be $75,000 or more. That's the jurisdictional amount. That means if you're not asking for at least $75,000, I don't care if you have pled facts to show that they violated the federal constitution, they're not going to exercise jurisdiction over it. So you need to make sure that you ask for at least $75,000. I'm going to go ahead and tell you to ask for an amount so unreasonably large that you're going to have to, it's going to take a long time to negotiate a settlement. Put it like that. Where is his complaint? I know it's in here. Is this? No, this ain't it. This ain't it either. Is this? I don't think this is, because this case number ain't on here. Civil rules of pleading, civil rights, and constitutional violation arising from. That's not it. Where is his complaint at, man? I know it's in here. I might have passed it, y'all. Because I mean, okay, I think we're getting to it now. What is this? Encampment of Israel. Not really sure why he got that in there. Order of lawful authority. He's right there. Let every man be subject to the higher authority, because no authority exists unless God has permitted it. So what comes first? Obviously God. And then what? Man, we the people. And then the state by the Constitution. This is why I tell people the people can nullify every Supreme Court decision that they don't like whenever they want. Just like the legislature can write out of existence every municipal corporation that they authorize to exist. They can do that whenever they want. And they don't have to give you any notice of it because they created it. Anyway, federal by Constitution through 10th Amendment, national government, corporate, District of Columbia, voluntary by Constitution of Maritime Amendments, U.S. citizen. I agree with that. He has this. I don't know who did this, but this is set up right. I agree with all this. What is this? United States of America, 50 states. We are the people, inhabitants. That's right. Created by the people. Substantive, unalienable right. That is right. That is right. Fundamental rights. That is right. DC subjects, 14th Amendment persons, privileges come. Yep, that's right. I agree with all that. He must be cited. I think that's a Bible verse right there. Leviticus probably 25. Let me go and see what that say. Leviticus 25, 44 through 46. Let's see what it say. Your male and female slaves are to come from the nations around you. From them you may buy slaves. You may also buy some of the temporary residents living among you and members of their clans born into your country, and they will become your property. You can bequeath them to your children as inherited property and can make them slaves for life, but you must not rule over your fellow Israelites ruthlessly or whatever. Okay, I see what he's saying right there. Let's get to his complaint. I think this is his complaint right here. Yep, this is it. All right, this is his complaint. Ohio. So it's in Ohio. These are all the people he sued, y'all. A lot. He sued a lot of people. First Amendment complaint for damage of civil right. He did his research, man. So this is what you'll be getting once you sign up for the jury membership, or if you just send me $3 or whatever, and I'll send you this stuff. You're gonna pay me for my time. You're not paying me for the information. You're paying me for my time. Ugh, I'm hungry. I gotta get something to eat. I gotta get out of here, y'all. Robert, thank you, Robert. I really appreciate that. I really do. You didn't even have to do the novice litigant, but I really do appreciate that. Thank you. Um, uh, let me go. I'm gonna come back and read some of these comments, y'all. Okay, are you drinking lots of water when you do these marathons? Sometimes I do. I'll review it after you're done. We got you. Hard to think if you are hungry. I know how it is. I get grumpy myself. Yeah, I was kind of fasting, but I got to get me something. I'm probably finna order me something to eat because I don't feel like cooking. Thank you again, Robert. Oh, upgrades. Okay, I'm gonna cash up you for the Dropbox. Okay, appreciate that, David. Appreciate that. Makes sense. Thank you. It's raining money now. Rather just send you money or do your group. I think being a member shows, and you end up in the algorithm. I'm not really sure about that, Robert. I'll send Aussie Silver if you have a PO box. Dang it, restricted message. How do I? Why do they put the message restricted? How do I do? Hide user from this channel. Add moderator. I don't know. I can't. I couldn't even read the comment, SG. I'm sorry, man. It blocked it out. Towards the top page. 389 said complaint on it towards the top. Jury notification, Leviticus. Um, hey, bro, I sent you a cash app and email. I appreciate that, David. Give me a second. I'm getting ready to get off here. You need a good woman to take care of you. You're cute ass. Woo! I almost just said something. I really did, cause man, if I get a hold to a woman right now, man, Lord, whoo, I got a lot of build. I got something built up. So if I get a hold to a woman right now, man, I ain't gonna turn her loose. I'm gonna turn her every way but loose. How I'm feeling right now. Uh, all right, y'all. I gotta go. I've been on here longer than I anticipated because I was not supposed to be on here this long. Um, but this is some good information in this seminar, and I really think people, if you want to learn how to do this on your own at your own speed or whatever, I think you should do this. You answered my question. Oh, I didn't even know you can delete messages on here. Logistics are a problem for me. Let me get off here. Oh, I got a headache. I'm tired. Page 40. Why did? What is all this? He goes to. I think did they answer his complaint, Rick? I think they did answer his complaint. Did they? Let me see if they. Defendant police officers had no legal right to be at the premises at all times relevant herein in their capacity as a SWAT team engaged in forcible entry into the premises without a warrant or bona fide criminal process. See, just look how simple that is, y'all. Y'all see how simple that is? Man, y'all got to look. This is where it's at, man. I'm telling y'all, man. This is what got me 5 figures. I can't tell you how much. Even if I could, I wouldn't. No disrespect. Plaintiff's motion for summary judgment against. Oh, you motion for summary. I didn't even read all this. I forgot about this. Anyway, let me get off here, man, because I'll be on here all day, man. Let me get off here. I'm tired. I gotta get me something to eat. Woo! Look at all the men laughing at me about what I said about women. Man, look, man, look, man. let me get off here because I got a dirty mind. Let me get off here, man. Y'all ain't finna. No, let me get up off here, man. Let me get the hell off here. All right, y'all. Everybody enjoy your day. I'm not sure when I'm gonna come back and do another live, but David, give me a little time, David, and I'm gonna send it to you. And I do appreciate it, and I thank y'all. That'll be the end. The Supreme Litigant is out. Peace.